Welcome everyone to Franczek's School Law virtual session on the OMA Meets Zoom. Considering the world we are all navigating now, Zoom and similar platforms have become household names. They've especially impacted school boards. Since spring, school boards have been able to hold meetings virtually, and in June, the General Assembly amended the Open Meetings Act to officially permit virtual meetings in certain circumstances and subject to certain requirements. At times, the nuances of the OMA can be confusing, even for the most experienced boards, and adding a virtual element has elevated compliance concerns. In this session, we will address the new laws and weave those in with other OMA requirements. But instead of just a presentation, we are going to attempt to entertain you. We will be putting on a virtual board meeting skit. The actors today will be myself. I will be the superintendent. I am typecasted in that role. Nikki Baser is our board president. You will see her shortly. Jackie Werns is our board secretary. Dana Fattori-Crumley and Aaron Walsh are our fellow board members. So our goal today is to entertain and to inform. We're going to take some short breaks between, at times, our outrageous interactions as board members, and then we're going to provide some legal analysis. I want to provide a fair warning. There are a few places where we poke some fun at some people in the news. There was some low-hanging fruit out there that we couldn't resist. We mean no offense. We're just trying to add some levity to this. And I'm sure you will have questions as we go through this. If you just provide those questions, and we will try to address as many of those as we can at the end. Okay, let's get started. Action. Okay.
Hi, everyone. Sorry we have to get together on such short notice. I'm glad we were able to post the notice last night. I think it's really important that we get together to talk about all of the issues on the agenda before the meeting starts. Maybe the three of us can discuss a few of the items before the superintendent and others get on, and before we let the public in so that we can reach consensus.
Hi, everyone. Sorry I'm a bit late. Did I interrupt something?
Oh, hi, Superintendent. No, it was nothing.
Okay, we're going to stop there, and Jackie's going to provide us with some our legal analysis for that first part of the skit.
All right, everyone, welcome. I'm Jackie Werns. So we're going to talk here about, was there a meeting before the meeting? So you saw that Nikki and Aaron and I were all here, and let's assume for our purposes of our board that we are a majority of a quorum. And so the question is, nobody from the public was let in yet, as Nikki mentioned. And Nikki started talking to us about some things that she was hoping we could discuss before the superintendent joined us and before we opened up the room to the public. So during this discussion, we haven't really hit yet on any public business. And yeah, I'm seeing a comment that says it's almost an OMA violation. We haven't really talked about any public business, but we were right on the edge about to do so, right? So we wanted to give you this as an example of some of the risks that can come when you start your meeting in the background without the public being present, but where you might have a majority of a quorum of the board who are there. It's very natural for us now all to want to talk on Zoom. So it really is a matter of discipline. We're not going to tell you that you can't use a waiting room. We know that for practical purposes that can often be a very important tool, but you are going to have to manage that line between making sure that if you have a majority of a quorum of the public body there who are present, that you not talk about public business. And if you don't think you can manage that line, just let everybody in at the same time.
I think the key term, Jack, is just discipline at that moment.
Right. And we all know how very disciplined we all are on Zoom these days, right? Absolutely. So we can do it. Nikki also mentioned that she was sorry that we had to get together on such short notice and that she was glad we were able to post that notice last night. Did anybody notice anything wrong with that? Because you should have, because there is a 48-hour notice requirement. Yep, I just see a comment here in the chat, 48-hour notice requirement unless there's an emergency. All right, we're going to get back in character now.
I'm never out of character. I would like to call the virtual meeting of School District Partly Cloudy to order. It is 12 p.m. on Thursday, October 29th, and we are meeting via Zoom. This is a virtual meeting because all of us have gotten used to participating in meetings in our pajama bottoms, so why change now? Hopefully everyone is cozy at their own house and no one is at the board meeting room since there is no one there. Secretary Werns, please call the roll. Secretary Werns, we cannot hear you. I think you are muted. Yes, it's you. We need you to call the roll. Please unmute yourself.
Oh, I'm so sorry. I was on mute. I'm really sorry. My kids are all on Zoom calls right now with their friends, and my husband's on a conference call, and the dog just started barking at the Amazon guy who's delivering our groceries, and I'm trying to finish my Peloton ride. Oh, anyway, all right, roll call. President Baser.
Present.
Member Walsh. Secretary Warrens is here. I understand that Member Walsh's audio might not be working. Is that right? Yeah, okay. But she can just provide a thumbs up or down when we vote. Totally fine. Member Fatori Crumley's on an extended vacation since March 13th. I think she's stuck in Cozumel. Member Trump refuses to participate in virtual meetings. He said we're just going to mute him anyway. Member Biden has no internet access in his basement. And Member Coney Barrett was too busy with work and raising 7 children. Superintendent Crowley is present. President Baser, we don't have a quorum, but there's not really anything all that controversial pervading society or schools these days. So let's just hold the meeting.
Sounds good. Let's get started.
All right, so we are going to stop there. I want to make sure I wasn't muted. Give me one moment here. All right, so we're going to get started. So regarding virtual meetings, there are certain elements that we have to meet as a board to have them. So one, the governor must have issued a disaster declaration related to public health concerns, and the school district has to be located within that disaster area. That is not an issue right now. The whole state of Illinois is within a disaster area. The governor has been reissuing these orders since the spring. The current one is due to expire on November 15th. We fully expect him to reissue it as of November 14th. I think for the foreseeable future, due to COVID numbers, we will be within a disaster and virtual meetings will be an option. The next requirement is the head of the public body, the board president or the superintendent, has to make a determination that an in-person meeting is not practical or prudent because of the disaster. And here, we would typically want that on the agenda itself, and it's not clear if we've done that or not. If we have, good. And what we recommend to our clients is place that finding on the agenda itself. But the next step then is at the board meeting, which we did not do, is we need to state the nature of the emergency and why we're in a virtual meeting. That has to happen at the beginning, and the board president should do that. Wanting to wear pajama bottoms is not a permissible reason, so we failed there. Next, we need to verify that we can hear everybody. So we couldn't hear Jackie initially, but we were able to remedy that. We can't hear Aaron either, apparently, although we'll all hear from Aaron on our analysis, but during this meeting, we won't be able to, and that's a problem. You absolutely have to hear each board member. You have to hear their discussion, and you have to hear how they vote, and that leads to voting. All votes in a virtual board meeting must be by roll call. So while in an in-person meeting, we can sometimes do voice votes, in a virtual meeting, it must be roll call. The next step is we need to make sure that members of the public who are attending the meeting at the meeting room can hear and watch the meeting. So if we don't want the public there because we think it's unsafe, we need to make another finding stating that it's not feasible for the public to be there, and then provide for alternative arrangements, say a Zoom platform for them to watch it contemporaneously. And that needs to be in your notice as well. Another requirement is that at least one member of the school board, the chief legal counsel, or the superintendent need to be at the meeting room, unless we make another finding that that's not feasible either. So if you don't want anyone at the meeting, you need to have 4 things in place: governor order, head of the public body making that determination, then a separate determination that the public shouldn't be attending, and then a separate determination that a school board member, chief legal counsel, or superintendent can't make it there either. And most of those should be in your agenda with the board president at the start of the meeting, stating that it's not feasible to have this meeting in person. And then we'll get into this a bit later, but you also have to have a verbatim recording of the open session portion of your meeting and of course of the closed session portion too. So let's then go beyond the virtual portion of this, the other problems with this meeting. All meetings have to be convenient and accessible to the public. I think an argument could be made that 12 p.m. on a Thursday may not be convenient and accessible to the public. That's during work hours. Many of us are dealing with children remote learning right now. So, and really what that comes down to are the subject matters you're discussing before your board. If it's really innocuous, vanilla items, maybe that's okay. But unlike what Jackie said in her statement, schools are at the forefront of all issues right now. And especially if we're talking about reopening schools or closing, that needs to be at a time convenient for the public, for people to see you and to participate. 12 p.m. is not appropriate for that. Another issue, the quorum. We do not have a quorum right now. We only have 3 members participating. For both virtual and in-person, you need to have 4 there. For an in-person meeting, 4 people have to actually be in the room. Now, if you have 4 people in the room at an in-person meeting, absent board members may participate, but they have to have an excusable reason. And those are illness, work, and family emergency. If it's not one of those, they can't even participate. And I've had questions, many questions, where people say, you know what, I'm on vacation and I want to be a good board member. I won't vote. You know what, I won't even talk. I want to hear, I want to see. And technically, under the OMA, they really shouldn't even participate or be part of that at all. Now, I think an interesting question arises for where we are today. And so again, for virtual board meetings, although Dana's on vacation, we're going to be able to have her participate even though she's on vacation because it's virtual. You can be anywhere you want for a virtual board meeting. For an in-person meeting, what if someone says, you know what, I'm concerned about contracting COVID. I disagree with the rest of the board. I don't think it's safe for us to be in person, but I want to participate. And the answer to that is we don't know yet. The PAC has not looked at that issue yet. And I think, you know, there's underlying issues that could come up with that. So for example, if you have a significant underlying condition, I think you'd have a much stronger argument to say that that board member can participate. If you don't, I think it's a more difficult argument to make. I think what it really comes down to is what are we acting on? What is the board acting upon at that meeting? And if there's significant issues, if there's gonna be a 4-3 vote, if we're acting on bonds, if we're acting on other things that require a specific vote or require an attorney to write an opinion based on that vote, I would really encourage you to reach out to your attorneys if there are board members who wish to participate remotely because of concerns about COVID. All right, I think we're ready to go to the next part of the skit.
And Brian, there's a few questions in the chat for you, so.
Sure.
All right, okay, I will text Dana and ask her to participate. Oh, looking at my text reminds me of the text Secretary Warren sent me during the last meeting regarding the thing about that thing. I won't go into specifics here.
Oh, Member Fattori Crumley.
Member Fattori Crumley, you are muted.
Oh no, I'm so sorry. Greetings from Cozumel, everybody. As you know, I've been down here since March 13th. President Nikki, good to see you.
Good to see you.
Superintendent Brian. Oh, Superintendent Brian, I have to ask you a question. Can I just ask a question real fast before we continue?
Sure.
Can you send down some more Chromebooks? You know what they say about those sandy beaches in Cozumel. I need 3 more Chromebooks. If you could just FedEx them down.
You've got
the
it.
kids are getting behind.
You've got it.
Thank you. Thank you.
Well, thank you for joining us. We know that you have been on vacation, unable to leave, and there's just no rest for the weary. Superintendent Crowley, any public comments?
Well, thank you, President Baser. We did not include public participation on the agenda since it is a special meeting. As you know, at our regular meetings, we have not permitted members of the public at the meeting due to the current public health crisis. Our boardroom is too small to accommodate the public with the current social distancing guidelines, and frankly, everyone's been so negative lately, it just feels good to keep the public out. I do have some emails from the public that we did not get to at our last virtual meeting since members of the public are typically limited to 30 seconds. Public comment is limited to 15 minutes in its entirety, and I tend to be a very slow reader. Also, not many of the emails qualify for sharing as they do not complement the hardworking board members. Were not submitted 2 weeks before the meeting and include no address and are not limited items on the agenda. Finally, since this is a special meeting where there would be little interest, to save money on our Zoom account, I limited the number of people who could watch to 50.
Thank you for your fiscal stewardship, Superintendent.
All right, we're gonna stop there. Jackie's gonna take the legal analysis here.
All right, so Nikki mentioned those text messages that we were sending to each other at the last meeting. And we just wanted to remind you that text messages, even between two board members during a board meeting, are public records subject to FOIA. Courts have generally found that board members are not acting with executive authority when they are acting without a quorum, but several exceptions do exist. So messages created on a private device, an account can be subject to FOIA if they are forwarded to a public account or a device or sent to a quorum of the board, and also if they are created during a meeting of the board or a committee of the board. So we want you to be careful with that, and remember that meetings of a public body under the OMA can occur electronically, so definitely be careful about anything that could be interpreted as contemporaneous communication between a majority of a quorum, even outside of board meetings. Also, it is really hard to talk after riding a bike, so.
You're doing a great job. Okay, I'm going to talk a little bit about public comment. I know you all were hoping and praying that you could in fact just shut down public comment as Superintendent Crowley had done, but of course you need to provide at least one opportunity for public comment during any regular or special board meeting. Public comment should be included on each agenda, and it can happen at the start of the meeting, at the end of the meeting. That's your choice, but it has to appear on any for any board meeting, and you have to include it on the agenda. So we've gotten a lot of questions surrounding public comment for virtual meetings. Again, as Brian said earlier, members of the public must still be allowed to attend a meeting and to publicly participate unless a separate finding is made that it's not feasible for members of the public to attend due to the pandemic. So in such case, the board has to provide an alternative arrangement to allow members of the public to participate contemporaneously, to hear all discussion, and to have some sort of public participation. So we don't really have any law at this point about participation at an all virtual meeting, but you have to provide something. So I know most of you have taken the route, which we have discussed and recommended, of allowing folks to submit emails in advance, and those are read aloud or they're provided to the board members, and that is certainly one way to allow for public participation. So, you know, some allow, you know, members just to speak on Zoom. There's lots of issues with that sometimes from a logistical standpoint. So again, a lot of our districts are doing the email route. If the public is able to attend the meeting and the board knows, perhaps you're talking about your reopening plans, that it's going to be well attended. We now, of course, have even further restrictions on the number of people that can attend. And so what you would want to do is make sure that you have space available. Again, if you're all open to the public, make sure you have some overflow rooms so that people can come watch the meeting, and then when it is their turn to participate in public participation, they can come into the main room. One of your administrators can exit, so you're maintaining those numbers. They can speak, and then they can go back to the overflow room where they can hear, like, you could simulcast the recording or the board meeting in that way. And again, public comment rules can apply. So again, we've got a lot of questions about how many emails do we have to read? What if it's 7 hours of emails? Public comment rules can apply to the reading of emails. Again, what we have recommended is, and I know Brian's going to talk a little bit about the length of public comment, so he'll talk about that also in the context of virtual meetings. Again, meetings must still be accessible to the members of the public. We had a note here about limiting the number to 50. That's certainly a problem and would create a violation if members can't log in, if there's just not enough space on the video conference. So definitely your Zoom account is not the place to sort of exercise fiscal restraint at this point. The last thing I wanted to say about public comment, because this is a question we're also getting a lot of, is what if someone submits an anonymous comment? Do we have to read it out loud? The position we've taken at this point is that no, you don't. Obviously, in public participation, if people came live to a meeting, they would be there, you would know who they were. I think if anonymous emails are submitted, I would provide them to the board so that the board can review them, but I wouldn't necessarily read those out loud at your board meeting. But obviously, it's your option to do so. Brian?
Yeah, so I'm going to continue here. I mean, I think we have an incredible tension right now between public interest in what schools are doing and health issues. So we have hundreds of people who are concerned about the reopening of school, but we also have limitations on what we can do in our boardroom. And so as a board, as a school district, you are permitted to provide for reasonable restraints regarding public comment. But those reasonable restraints must be in your board policy. Now, with that said, we haven't had necessarily time to assume that we were going to have a major pandemic and deal with all those issues. But let's go over some of the rules that we had, that Partly Cloudy School District had in place that were frankly wrong. So the first one we said is that we only allow people to speak 30 seconds. That's, hopefully everyone realizes that that's absurd. The minimum that we typically see is 2 to 3 minutes. I would tend to err on 3 minutes. Sometimes we allow 5. That should be in your rules though. Another one, this is to the question of, do I have to read every single email that comes before me? And the answer to that is no. We can put limits on the total duration of public comment, but that really should be in your rules. So pre-COVID, I had some issues where a school district put a limit, said, hey, we're only going to talk for a half hour. That was not in their rules though. And so that was deemed a violation by the public access counselor, not necessarily because they limited to 30 minutes, but because that limitation was not in their rules. So again, you can put a limitation on the total duration, but make sure that it's in your board policy. That's essential. The other rules that we had in place, I like to consider these requests versus requirements. I don't think there's anything wrong with requesting certain behavior of members of the public for public comment, but there are certain things we just can't require. So obviously our one requirement that people had to get to us 2 weeks ahead of time to tell us they wanted to make public comment, again, absurd. We can't provide for that. And if you're in an in-person meeting, if someone's there in a timely manner, maybe they didn't sign in on time, but they're there at the time of public comment and want to get up and speak, I would let them speak. I do think the calculus changes a bit when we're talking about virtual meetings, because we have to get those prepared. I mean, for our own meeting here, we had to get prepared 15 minutes beforehand to get situated and such. And that's the same, obviously it's the same for you when you're dealing with hundreds and hundreds of emails. So I think that there it is fine to put a time limit and say, we'll take your public comments by email, but you need to get to us by 5 p.m. before a 7 p.m. meeting. I think 24 hours would be too much, but there I think an appropriate cutoff is fine. Also true for if we're going to allow public comment through Zoom. It can't just be a free-for-all and just see if someone's raising their hand. Again, I think there it's fine. If you want to make a public comment by Zoom, if we're offering that, tell us by a specific time, and then we will identify you and allow you, you can address the board at that time. We cannot require members of the public to provide their address. There's actually a specific public access counselor opinion on that. Again, I don't have an issue with making that request and saying we'd like you to provide your address, or we encourage you to. It's helpful for you all to know if they're a resident of your district. But if someone refuses, they still get to speak. Obviously, we can't limit comments to positive comments of the board. If people want to criticize, they can. I bring this up though, because I have seen rules and actual rules in place where they say you are not to speak about personnel matters. And if someone wants to speak negatively about an employee, about the superintendent, certainly of the board, and they're not acting it's not libelous, they can, and they need to be permitted to. Now, again, there's nothing wrong with encouraging people and saying, listen, we have other avenues for you to make your concerns known, and that's a more appropriate and constructive way to go about it. But if someone says, nope, I want to say some negative things about the superintendent, they need to be permitted to do that. And then finally, we had another requirement that you could only speak to matters on the agenda. If someone wants to speak about anything that's relevant to the school district or about the school district and the school board, they certainly can. If someone wants to speak about national politics and it really has no connection to the school district, that would be appropriate and you could stop that speech.
Yeah, and I'll follow up quickly on this. Brian mentioned the issue of, not talking negatively and all the restrictions and requirements that you can have. And obviously just a reminder that this issue intersects with the First Amendment, and public participation directly impacts, speakers' rights, First Amendment rights to speak to the board. So again, the rules are okay, even within the context of the First Amendment, as long as they are content neutral. So again, you're not saying you can't speak negatively, but you can speak positively, which was what we talked about in the skit. That would be the definition of something that was content specific or viewpoint specific. So again, your rules have to be content neutral. They have to be narrowly tailored. So the 3-minute limit or the 4-minute limit, obviously your purpose as a board is to carry out the business of the board. And so it is a reasonable limitation. It's narrowly tailored to try to make sure that people have time to speak, but that it doesn't go on for hours and hours, and leave open alternative channels of communicating the information. So oftentimes demonstration about an issue, and that's fine as well. Again, regulations, you can certainly, as a board or as administration, remind folks who are speaking about concerns. But you want to make sure that you're not running afoul of their First Amendment rights. I'm having a little bit of internet issues, so we can just move on.
All right, back to the skit.
All right, let's move on to the action items. We have several. First, can I get a motion to approve the minutes from the last meeting?
President Baser, Secretary Werns asked me to prepare the minutes from last month. I was not at the meeting and I have no idea what you talked about, so I just copied the agenda and then wrote down the vote. Sounds good to me. Okay, motion to approve the minutes. Second? I second. All those in favor say aye.
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 The next matter on the agenda is approval of an emergency bid to replace the boiler system. Superintendent Crowley, can you explain this one?
Yeah, sure. Due to budget constraints, I've been handling the building and grounds work. This was not one of my better ideas. I have no idea how a boiler works. When the weather got cold, I kicked it a few times, but it would not start. So I would like to hire someone immediately to replace the boiler.
Okay, let's get a roll call vote on this one.
All right, Member Walsh. Member Fattori Crumley.
Oh, I say no. I say no. Superintendent Brian, did you try that on switch first? No, my vote is no.
President Baser.
Yes.
I abstain because I just really want this to end already so I can finish my workout. The motion fails with 2 yes votes, 1 no vote, 1 abstain, with 3 members absent.
What do you mean it didn't pass? 2 voted yes and only 1 voted no.
Yeah, but I abstained, and that goes with the no votes. So it really was 2 on 2.
That doesn't make sense to me. President Nikki, I think you should just whip out your cell phone right now and let's call the lawyer.
Lawyers are overrated and they always make the meetings so long. We can figure this out ourselves. Just look at our Robert's Rules of Order.
Board, one of the reasons you hired me as your superintendent is because I am a stable genius. Also, no one understands Robert's rules better than me. Believe me. First, a person voting the majority needs to make a motion to reconsider. Then we need to vote on that motion. Then we need a motion to put it on the table. Once it is on the table, we can leave it on the table until the next meeting when we can take it off the table by a majority of those who voted in the last vote prior to the motion to reconsider the rescission of the approval before the table to take it off the table prior to reconsideration. Does it make sense?
Absolutely. All in favor say aye.
Aye.
Aye. Moving forward, motion for approval of the consent agenda. All those in favor say aye. Aye. All those opposed.
Nay.
Member Fattori Crumley, I did not hear your vote.
Oh my goodness. I'm so sorry. I'm just looking at my watch. It's time to put my sunscreen on again. Just give me a minute. Give me a minute.
Okay, I'm just going to mark you as abstain. Okay, so 2 yes, 1 no, and 1 abstain. Since I was a yes, we'll just say everything passed. By the way, the agenda only says consent agenda. What was included in the consent agenda?
Really some innocuous items. There were a few bills to be paid. Under the personnel item was my 5-year contract extension. Thanks for that, by the way. We terminated a tenured teacher, and we decided to close the high schools but reopen the middle schools.
Sounds good.
All right, moving back to analysis.
So
My microphone actually does work. I'm just trying to fool everyone because I don't really want to participate. But I'm going to be talking a little bit about the minutes. So though the minutes do not need to be verbatim, they need to provide a summary of the discussion that took place. And what that summary would entail is really the time, date, and place of the meeting, members recorded as present and physically present or by other means, and then a summary of the discussion on all matters proposed or decided, and a record of any votes taken. Now, it's okay to vote by voice vote, but at a virtual meeting, all votes must be by roll call votes, and those watching must be able to hear the vote. Now, finally, I just want to point out that closed session meeting minutes also need to provide the same type of information as that is required for open meeting minutes.
All right, so let's get into, I think that was supposed to be convoluted and confusing. So let's get into the actions and the voting of that last session. So as Jackie stated, the agenda itself earlier, we need to have, if you want to take action on an agenda item, if you want to take action on an item, it needs to be on your agenda 48 hours before the meeting. Here, I'm emphasizing the consent agenda here. It appears that we didn't have any, we just had consent agenda. And so as a result, any action on any of those items was not valid. Now, sometimes I know things come up and you want to discuss items and maybe you've missed it for your agenda. For a regular board meeting, discussion of an item is fine. And you can do that. You just can't take action on it. Now, a special board meeting is different. A special board meeting, you are constricted by what's on your agenda. Action itself, when you're acting, it has to be preceded by a public recital. I'm reading from the OMA here. It must be by a public recital of the nature of the matter being considered and other information that will inform the public. Basically, in layman's terms, the public needs to know what you're acting. They need to have a sense of what you're acting upon when you act upon. You need to state that orally. Here we just said approval of the consent agenda. Those items weren't even on the agenda, and we didn't state those various reasons. So if we had had those on the agenda, the appropriate motion would have been, I move we adopt the consent agenda, which includes approval of the superintendent's employment contract, termination of a tenured teacher, reopening of the schools. Now, I don't have an issue with consent agendas. It's a nice way to try to expedite the meeting. Typically, they should be for items that don't require much discussion, and we can get through them quickly, and that's fine. But again, you can't just say, I move to approve the consent agenda. You need to list those items out. Next, voting. So typically, for most board actions, it's a majority of those voting on the issue. An abstention is not a vote, and I know that can get confusing at times. So we look at how many people voted, and if a majority of those voting approved it, it gets approved. So looking at our specific votes here, the first one was the boiler. It was 2-1 to 1, so 2 yes, 1 no, 1 abstention. Was it a true emergency? It sure didn't seem like one. And for a true emergency, you need 3/4 of the full board to vote. So again, with most actions, it's a majority of those voting. But there are certain statutory requirements for other actions where specific votes are required. An emergency bid is one of them, where we need 6 yes votes. Here we only got 2 yes votes. Looking at the items on the consent agenda, one was expenditures. That only requires a majority of those voting. But remember, this was a virtual board meeting, and we all did just a voice vote. We didn't do a roll call. And if you don't do, so you have to do a roll call if you're virtual. You also, if you're in person for expenditures, you must do a roll call vote. If we had done an appropriate roll call vote, the expenditures passes because we got 3 total people voting, 2 yes, 1 no, 1 abstention. The superintendent contract, thank you, would also have passed. For superintendent contract, you only need a majority of those voting, so it was 2 to 1 to 1 again. For the termination of employee, that's another specific, it's a termination of a tenured teacher. You need a specific vote requirement, which is a majority of the full board, which would be 4 yes votes. In this instance, it would have failed again because we were 2 to 1 to 1. Jackie's going to go into a little bit more on the termination of tenured teachers.
Yeah, so with terminations, the board should state the name when approving the termination. And this can get a little bit tricky. We know sometimes people ask if they should have the name on the agenda. And our typical advice is that From an OMA perspective, that may be the best thing to do. It may be correct, but what if you decide not to terminate the person? There might be some constitutional issues that come into play there. If you're going to terminate and not be sure, then be as specific as you can without naming the person. And then in your action, you're going to name them at that point.
I also just wanted to mention about, there was the Brian's great description of the things that were on the table and then they were taken off the table and the Roberts rules. I am sure you were as confused as the board was. I know that there's a lot of folks who understand what Roberts rules are, but don't really have a full handle on how, all of the extensive motions that fall into Roberts rules, all the voting practice. One of the things that we did want to mention is that we actually at Franczek developed a much more streamlined set of rules. We actually refer to them as Todd's rules because they were developed by Todd Faulkner. And if anyone out there is interested in hearing about them, let us know, call any one of us. The purpose of them is, they're about 3 or 4 pages. And the idea is that it streamlines the motion practice, it streamlines the discussion practice, and everybody on the board and everybody in the public can be on the same page because the processes are simple and straightforward. So if anybody is feeling like Robert's rules are not as conducive to running a board meeting and would like to check out Todd's rules, let us know.
And if I could just add to that, Robert's rules are not meant for the type of body that a school district is. It's meant for a large legislative body. So much of it really doesn't make any sense for a school board. And I think if you do find yourself getting entangled in Robert's rules, again, we would suggest utilizing something like Todd's rules. But if you're in the moment, you can actually take a motion to just waive Robert's rules and just get rid of them for that action and get out of that entanglement. So again, Robert's rules isn't always the best set of rules for a school board. All right, why don't we go back to the skit?
All right. Can I get a motion to go into closed session?
We're going into closed session? Why?
Board, as your superintendent, I got to advise you that we don't want the whole world to know the reasons. We'll talk about it after we move into closed session.
Thank you for the wise counsel. I move we go into closed session. All in favor? Aye.
Aye.
Okay, now we're in closed session. Let's discuss the litigation matter. Superintendent Crowley?
Thank you. Well, before the board's time, the prior school board purchased a property owned by former board member Dalianis. Turns out there are some leaky underground storage tanks that may be contaminating the neighborhood homes. The school district received a letter from a disgruntled neighbor stating her displeasure.
Wait a sec. There's just a letter? There's no lawsuit? I still think we should get that lawyer on the phone. Let's get him on the phone.
No, I think it's enough. I mean, it says my water tastes like oil. You better fix this soon or else.
By the way, that purchase was a bad idea from the start. I think we should sell the property and cut our losses. I talked to Mr. Dalianis again. He would be willing to take it off our hands for 50% of what we paid him for it. Member Dalianis did great work for this board. I think we should cut him the deal, and then we can avoid these neighbor issues. Let me get a motion to approve selling the property back to Mr. Dalianis at 50% of what the school district paid for it. All those in favor say aye.
Aye. Oh, okay. I know Member Warrens wants to get back to her workout. Can we just get to the self-evaluation part? I mean, personally, I think we're all just great. Anybody else?
It's agreed. We are doing a great job. I move we adjourn. By the way, Superintendent, when this is finished, please immediately delete the Zoom recording. We do not want Member Trump or Member Biden to see it. All those in favor? Aye.
Aye.
All right. So we're at the conclusion of our board meeting. Anybody see any problems with that one? That one seemed pretty straightforward to me. There was just a couple. So first, you got to go into closed session properly, and this should be review for everyone watching. You need, while in open session, you need to state the reasons verbatim from the statute why you're going into closed session. So for us, we should have said we are going in for probable or imminent litigation. We also should have said we were going in for setting the price for real estate. Further, again, we're in a virtual meeting, but even outside of a virtual meeting, it's an in-person meeting, so you have to do during closed session, you need a roll call vote. A voice vote does not work. Once we're in closed session, there's a little issue with probable or imminent litigation. There's another requirement for you to do. You need to state on the record in closed session for that verbatim tape why you think it's probable or imminent. So in this instance, the superintendent was saying we got this letter from this neighbor. Now,
Hey, Brian.
yeah, sure.
Oh, you were something was going on with your voice, so maybe you could try it again.
Sure. Throughout the whole.
For most of it.
I think it was mostly like the real estate part, like the probable imminent litigation. We got through.
Okay. So
Yeah,
getting
people
back
are saying
to
people are saying to please start over. So why don't you just
start over completely? Okay, I'll start over. All right. So we made some mistakes there going into closed session. So one, we didn't state the reasons verbatim. So this should be a review for everyone watching. When you go into closed session, during open session, you would state the reasons from the statute why you're going into closed. We should have stated we are going into closed for probable or imminent litigation, for setting the price for a real estate sale. Second, we didn't take a roll call vote. We did by voice vote. Regardless if you're in a virtual board meeting where, again, you always need a roll call vote, or in an in-person meeting for closed session, it must be a roll call vote to go into closed session. Once we're in closed session, if we're discussing probable or imminent litigation, we need to state on the tape why we think the litigation is probable or imminent. That needs to be on the tape. So here, the superintendent should have said, we got this letter from this neighbor. I think they're going to sue us. Now, with that said, that would have never passed the test for probable or imminent litigation. The public access counselor looks at that very strictly, and it's pretty much, it needs to be a letter from an attorney saying we're going to sue you, and or the school board itself preparing for imminent litigation to meet that exception. Regarding the setting of the price for real estate, I think we've got a lot of side conflict issues with former board member Dalianis that we won't necessarily go into. But if we had only, that conversation seemed to evolve as we were talking about the litigation. If you find yourself in closed session talking about a matter that you didn't go into initially for, you need to come out of closed session, back into open, say, by the way, public, we're also going into closed to discuss the price for real estate, and then go back into closed. Now, again, closed session is a discussion item. So that is an item that can be added to a regular board meeting agenda at any time. So if you get a lawsuit filed against you 10 minutes before the board meeting starts, and you didn't even plan to have a closed session at that meeting, you can go into closed session to discuss that, even if it's well after the 48-hour requirement, because that is a discussion item. But that leads to probably our biggest mistake at all through this. We took action on the real estate in closed session, and that really is the ultimate ultimate violation of the Open Meetings Act. And I would say, as someone who's been dealing with the public access counselor and alleged OMA violations for quite some time now, typically the consequence of violating the OMA is the Attorney General saying, don't do that again, improve your practices. And I have not seen any client with any sort of malintent or malfeasance on it. It's usually a mistake, or frankly, we're right, and we followed it appropriately. But if you're acting in closed session on them, that's when you might pique the interest of the state's attorney, because ultimately violations of the Open Meetings Act do have criminal consequences to them. I, in my career, have not seen that occur with any of our clients, thankfully, but that would be the one issue where we got to be really careful on. Now, with that said, there is nothing wrong with reaching consensus in closed session. And sometimes before you go back into open, you want to see where your colleagues are. So if you're talking about the superintendent's agreement, there's nothing wrong with taking a quick poll of everybody and saying, where are you, Bob? Where are you, Mary? Where are you, Jen, on this vote? And you can reach consensus in closed session, but you must come then back into open session and act upon it. And that leads to just one last issue on this. Many times school boards will have, going into closed session, action on items in closed session is on the agenda. If you are going to act on an item that you're discussing in closed session, let's say the superintendent's contract, that needs to be on your agenda. If you're not sure if you have your board votes for that action, and using the example I just provided, don't want to embarrass the superintendent, what I would do then is talk about it in closed session and vote on it at another meeting where you can put it appropriately on the agenda. So Aaron's going to go into the recording part now.
Brian, before we do that, there was just a couple of questions I thought maybe you could answer quickly. I know we have a lot of questions, but these were specifically about going into closed session. The first was, do you have to cite the school code, or can you just say something like litigation? And second, what if a board goes into closed session for the same reasons every meeting? They just always have the same list. Can they do that? Or does it need to be specific to that meeting?
Yeah. So you do not need to state so you have two choices. You can state the actual statute, so section 5(2)(c), or state the litany from the statute. And I think that's the better way to do it. So litigation, for example, is in the statute, and that's completely appropriate. That's enough. You don't need to state the citation. That's at least your second question is one I've received quite a few times where people just say, hey, we just list the whole thing every single time. So we include the price for real estate, and even though we're not talking about the price for real estate in closed session. My feeling is I think that goes against the spirit of the Open Meetings Act, frankly. The public is supposed to know what you're going in to talk about. So if you're not talking about litigation, you shouldn't say it in your closed session litany. And I know the reason for that, again, isn't malintent. It's just that we don't want to miss anything. We don't want to forget anything. And just it's a nice reflex and a nice filler. But I think it's more appropriate and a better practice to list the specific reasons why you're going in.
Yeah, and for that same reason, Brian, I think that's why, listing, yes, you can list the statutory section, but if the purpose of this law is really to try to help the public understand what's going on, reciting what the actual exception is for is going to be the better way to go about it. All right, Erin, you want to tell us about recording?
Yep, so specific to recordings, at any meeting, the closed session recordings must be retained for 18 months. Now, at a virtual meeting, whether it's opened or the closed session, those recordings must also be retained. Now, it's our interpretation that open session virtual recordings can be destroyed after 18 months. Now, it's also worth noting that board members must be given access to the closed session recordings, provided that they're reviewed at the school district's main office or their official storage location, and in the presence of either the record secretary, an administrative official, or an elected official of the district. Now, finally, no verbatim recordings may be re-recorded or removed from the public body's main office or official storage location, except by vote or by a court order. So again, the rules are pretty strict in terms of board member can't just simply go in and say, hey, in this meeting, I want to hear the closed session recordings. Can I take it home and then come back and just bring it back? That's not acceptable under the rules.
Erin, let me just add one thing to the question I've received before where a board member wants to listen. It's maybe a dysfunctional board and another board member wants to be there to witness their listening, if you will. And that's fine to have one other there. Remember, if you get two there, we've got a majority of a quorum, and now we have a board meeting all of a sudden. So just be careful of that.
So I'm going to wrap up a little bit, and I'm going to take off my hat to do that and be serious and talk a little bit about just board self-evaluation and decorum at a board meeting. So first, just the rule about self-evaluation. A board can't, you can discuss self-evaluation in closed session, but there are some particular rules. And that means one of the rules is that you have to meet with a representative of a statewide association. And those are the Consortium for Educational Change or the Illinois Association of School Boards. And your district needs to be a member of one of those organizations. You need to have the representative present with you, and then you can have a candid self-evaluation process within the confines of closed session. A little thing that we want to point out: you can't adjourn when you're in closed session. So if you're going to end the meeting with a closed session and you're not going to have any action or any reason to come out, you still need to come into open session and adjourn the meeting from that open session portion of the meeting. And then finally, I think they gave me this topic because I was on a board and I obviously did not drink any alcohol. There were many like cookies eaten and sugary snacks, but no alcohol at the board meeting, and just appropriate decorum for meeting generally. This should be discussed with the board. I mean, it's a great time to discuss it at the self-evaluation, but how you present yourself at the board meeting, the etiquette for being on your phone. I know people might be dying to like check the Cubs score or the Hawks score, but like being on your phone the whole time just because the Bears are playing Monday Night Football and it's board meeting night is probably not a good message to send out there to the public. Remember, we've got people's kids, we've got people's money, got to not look like, but actually be paying attention and taking this seriously. So my little tip for that, which is a real life tip, is it goes back to when I used to teach 8th grade. If you have someone that's going to be sort of naughty and wandering, sit them next to the A student and have the A student model for them how they're supposed to act. So I obviously, during this past board meeting, I needed an A student to sit next to because I was not a good girl.
That was
I was not either. I was not either.
We're no agents in this group.
Yeah, you're at home if you're dealing with virtual meetings, you're at home, you have a lot of things you could be doing during that time. You could be working out, you could be watching the Cubs game, but it's not the time to do it, even if there's not a specific rule against it. So we did get a lot of questions, so maybe I'll just run through the questions. First of all, we got a very important question, which was about President Bazer's hat, which this hat is because this is Queen Bazer. She's our leader.
Yeah, and I see that Dana took off her cat. I am just never taking this crown off. Let's be clear. It's going to appear on every webinar.
All right, so we have a question. If we have all 7 members attending the meeting in person, but make it open to the public, both in person with a maximum of say 50 and open by Zoom, do we still need to record the meeting?
So if it is, the way I understand the question is that's an actual in-person meeting.
Mm-hmm.
The answer to that is no, you don't have to. You may want to, just from the pure fact of, again, the conflict I've been talking about with many people are interested, but we have a health crisis and not many people can come to the meeting. So, but that's within your discretion if you feel that's in the best interest of your school board and your community.
And do remember the open and available part of it. If it's something that is a really hot topic that that 50-person max in person might affect it, definitely think about providing other options for access. All right, so then we got a question of Brian. We have 3 board members who refuse to come into meetings. They have been virtual since March. They won't give reasons why other than it's not safe. Worse, they are seen out in the community and the community members are rightfully starting to demand that they are in the room. Would love your thoughts on this situation. We recently took that.
I saw it, yeah.
Okay.
I think that goes to my point earlier regarding, so that sounds like to me that's an in-person meeting. So as a result, if these absent board members want to participate, they have to have a permissible excuse under the statute. It sounds like to me the one they want to utilize is illness, but yet because of concern with COVID. And the PAC doesn't have an answer on that right now. And if they're, with that sort of tangential information, that they're actually out in the community, they haven't hunkered down in their home. They don't necessarily have underlying conditions that may hurt such an argument. Do note though that any sort of complaint would be against the board, not necessarily those individual members. And so we would have to address it as if a complaint came in, we would be addressing on behalf of the school district saying, perhaps defending their participation.
All right, so we had a question, what if the board goes into closed session for the same reasons every meeting, litigation, personnel, et cetera? Can they do that, or does it need to be specific to this meeting in particular? So I think that's getting at what Brian, you talked about earlier. I mean, yeah, I guess if the question is that you do literally talk about the same thing in closed session at every meeting, there's no reason that you can't have that list if you're actually going to talk about it. Okay, someone asked if there will be access to the recording. All of our school law conference sessions, like all of our webinars, are recorded. You can find them on our YouTube page. You can find them on our website under events. And if you registered for this, you'll also receive an email after the fact that has a link to the recording. So please definitely feel free to share it with your board or whoever was not able to attend. All right, how long does the recording of the meeting need to be available to the public?
I can take that one, Jackie. I think this is the question about virtual meetings and the requirement under the new statutory provisions related to virtual meetings that you do a verbatim recording of the meeting and that it be available to the public. I will say that the statute is not crystal clear. It refers back to another provision within the Open Meetings Act that relates to minutes and the closed session recordings as well. And so what we are advising at this point is that you post a copy of the recording for 60 days after you, it's up there for 60 days and that you post it within 30 days of the meeting. After that 60 days, we would recommend that you then retain the meeting recording for the full 18 months. And then you go through the same process you would with closed session recordings that you determine whether they can be deleted at that point. Obviously, if you have a FOIA request for the recording after those 60 days, you would provide it.
We have a question, if 3 or 4 members are in person and the rest are on Zoom, is that considered an in-person meeting or a virtual meeting?
Yeah, I mean, it depends on how you stylized it from the beginning. So it's really up to, in the day and age we're in right now, virtual is an option. So the board needs to make that decision. If only 3 are going to make it in the room, you can't have an in-person meeting then. So if that's what if you realize, love to have an in-person, we're only going to get 3 in the room, and you want to have that meeting, I would consider making that virtual. But remember, again, your reason has to be because of the health pandemic and because it's impractical to get everybody there. So, yeah.
All right, if your board policy states that you cannot name someone in your remarks negatively, is that allowed? Nikki?
Sure. So yeah, we talked about this a little bit before and I got a little cut off because of my my web access here. So this again is a First Amendment issue. What the courts have said is that you cannot have a rule that or across the board prohibition against criticizing certainly the board members, the superintendent, the administrators, even teachers publicly at a board meeting. You know, we would absolutely say that board members could recommend, you know, there's lots of tactics to use if someone steps up and starts to talk negatively about an individual teacher or an individual administrator. Obviously, you can caution someone, you know, that they need to be aware of defamation laws, invasion of privacy claims. You can certainly encourage a speaker to present the issues directly with the administrator. So let's say it's about a teacher, you know, hey, why don't you talk to the administrators about this separately? We'll set up a meeting for you, you know, or you can submit them in writing to us. You know, you can emphasize that any public discussion might harm the ability of the board to act or the administration to act. And, you know, if all else fails, invite them to come and meet with you in closed session. But at the end of the day, if they are insistent on criticizing a public employee in a board meeting, you do need to allow them their 3 minutes or their 4 minutes to do so. And again, we have seen courts come down on boards when they have not allowed that on First Amendment grounds. We get this question sometimes, the corollary with students. You know, if they're talking about another person's student negatively, at that point, I mean, I think there may be some First Amendment implications, but our advice is just shut the conversation down at that point. We're talking about a minor, and obviously give them the avenues to address the board or the administration on those issues in another way.
One thing to be really careful of on this point, though, and Nikki mentioned it, and Brian mentioned it, libel and defamation and all of those things. We tend to use those terms much more broadly out in the world than they really mean. So just remember that just because someone's saying something negative about someone does not mean that it's defamation. So I think we're at our time limit. So we're gonna let you all go. Thank you so much. If we didn't get to your question and you'd like to chat with us about it, please reach out to us And otherwise, we will see you next week for our next school law conference session. Thank you, everyone.
Bye, everyone.
Thank you.